Hey guys, today we're going to talk about due diligence in the probate process. Now, what exactly is due diligence? When someone dies, as you are aware, their estate needs to be managed and distributed in accordance with the will, or if he dies without a will, then in accordance with the Interstate Succession Act. And you need a grant of probate, which is essentially a court order to approve the will so that the institutions will release the money, allow the transfer of the HDB flat. Or if the deceased died without a will, then you need a grant of letters of administration. So due diligence essentially involves thoroughly checking and confirming the details of the deceased financial and legal affairs. This is essential to ensure that all the assets of the deceased are accounted for and included in the schedule of assets, which is a court document. So this essentially means that you have to do your homework to ensure that you have a complete picture of the estate. Why? Imagine this. If after distributing all the assets of the deceased based on what you know, and then you find out later that the deceased has had a hidden bank account or a forgotten life insurance policy. Now, this can be a huge headache for everybody involved, because then you have to take out an application to amend the schedule of assets to include that specific bank account or policy, and this application is costly. So when a person dies, the executor or the administrator may not know all the details of their financial holdings, their banks, their insurance policies. So what they can do is to start by looking at, they can go to the deceased house and start by looking for financial statements, letters from institutions, correspondence from CDP, from the, see if there's any letters from, brokerage houses, insurers. They can even look for if there's any existing or old wills to get a rough idea of what the assets are. Look, they can try to find the certificate of title of a property, HDB, title, deeds, whatever. If the executor or the administrator is not sure that he knows all the assets of the deceased, then he has to ask all the institutions. But how does the executor communicate with the institutions? Typically, most people will engage a probate lawyer who will then write a formal letter to the various institutions like the bank, the insurers, the securities trading company, where the deceased might have held an account or policy, and to ask them whether they have the deceased had an account or policy with them. If yes, to provide the account number, the details of the policy, or the amount left in the bank, the fixed deposit or the securities. Here's what the typical letter looks like. In Singapore, this letter has to include a certified true copy of the death certificate, a certified true copy of the originating summons, and a consent letter signed by the executor or the administrator in the presence of a lawyer. And this letter is done by way of a hard copy, an actual hard copy letter with the attachments, and is not done by email. They don't accept email. In fact, some banks don't even accept electronic signatures. They actually require a wet ink signature from the law firm on the law firm letterhead. So institutions usually take several weeks to check their records internally to find out whether the deceased had an account or a policy with them. So they may take a couple of weeks to reply, and this is what a typical reply looks like. So once all the institutions that the law firm has written to have replied, the probate lawyer will then be able to prepare the schedule of assets. You can watch my earlier video on the schedule of assets. So thanks for watching this video on due diligence in the probate process.